Good afternoon, Judge Green.
Good afternoon.
One moment, please.
Well, it's been slow, or it takes a while.
Warming up again.
Okay. We are on YouTube.
All right, thank you. You may begin with cross-examination, Ms. Weingarten.
Judge Green, your primary areas of practice included criminal law, family law, child welfare, and juvenile justice. Is that fair to say?
Not so much juvenile justice, I did some, but it was just very occasional. The rest is correct, yes.
So you've represented parents and children in juvenile court proceedings before?
Yes.
And have you tried cases in the criminal courts?
Yes.
Have you tried child abuse cases in the criminal courts?
No.
Have you handled cases that did not go to trial involving child abuse in the criminal courts?
I recall one case in particular. I'm not certain if I had more than one.
Are you familiar with the criminal laws relating to child abuse?
I'm familiar, yes.
So you're aware that reasonable parental discipline is a defense to child abuse. Is that correct?
Yes.
Before going to law school, you were a foster care worker and manager. Is that fair to say?
No, just foster care work.
Foster care worker, okay. What are the duties of a foster care worker?
Well, as stated earlier, they are primarily developing service plans for caregivers, usually parents. Sometimes those parents have had children removed, sometimes not, but they always involve families that are already in the juvenile court where a petition is already been filed. And so I developed service plans. I visited the children once monthly. I reported to the court on the progress of the parents and the degree of their compliance with the service plan. That would happen quarterly, usually.
Does a foster care worker need to have familiarity with the child protection law?
Well, I wasn't trained to have familiarity with it, but I found that over the years that having that familiarity helped assist me in my job.
As a lawyer handling cases in juvenile court, did you need to have familiarity with the child protection law?
Well, I did. I thought it was important, but it wasn't something that all lawyers were familiar with.
Were you aware that the child protection law requires CPS investigations to be confidential?
Yes.
And the reporting source of a complaint is also confidential, right?
Yes.
And are you aware that it's a misdemeanor to reveal who the source is?
I don't know if I know that it's a misdemeanor, but I know that it's contrary to law.
And are you aware that the status of the investigation is confidential until a final disposition is disclosed?
I wasn't aware of that.
Once CPS investigative reports are released, they can only be released to limited participants in the system. Is that fair to say?
It is fair to say, but that's not necessarily the practice. So to clarify, I believe that is certainly the law, but it's not necessarily the practice.
So are you saying that you are aware of situations where people get CPS investigative reports and they don't keep them confidential, but they show other people who should not be entitled to see them?
Yes.
Now, before your involvement in your son's case or this case, did you know Adam Baker, the district manager?
No.
Did you know a woman who testified, Bobby Jo Ferguson? Did you know Annie Ray?
Yes.
What role did she play? What was her title?
Well, I've known Annie Ray for all of the time that I've been in child welfare. So when I worked at Children's Center for that brief period before I went to Michigan DHHS, Annie Ray was the purchase of services worker for one of my cases.
So to cut to the chase, have you and she worked together or alongside of each other for many, many years?
No, we only worked together during that period when I was at Children's Center. But I did have additional engagement with her when I was at the Detroit Center for Family Advocacy, because we worked closely with DHHS in developing our services in that program.
And eventually, she became the head of the Wayne County DHHS. Is that fair to say?
Yes.
And she is one of the people with whom you met when you were complaining that Ms. Apple was biased.
Yes.
Are you on a first name basis with her?
Yes.
What about your relationship with Tiffany Mcdougall? Did you have a prior relationship with her before your son's case?
No.
And how about Mary Ann Kavanaugh?
No.
Lynette Wright?
Yes.
What was your relationship with Ms. Wright prior to your involvement in your son's case?
Well, Ms. Wright and I were actually friends many years ago when we worked together. Well, when I was at when I was a foster care worker, Michigan DHHS. So we were actually on the same team.
Did you hear Ms. Ferguson testify twice in this hearing, 2 different days?
Yes.
Is there anything that she testified to that you think was wrong or untruthful?
No, but I don't know if I'm qualified to testify as to whether things that she said were wrong, because I've never had any experience in the area that she works in.
All right, what about Mr. Baker? Did you hear him testify twice in this hearing?
Yes.
Is there anything he testified to that you believe was wrong or untruthful?
No, I don't think so.
Did you have any sort of relationship with the police officers who were at your son's house on June 18th of 2018? June 24th, I'm sorry.
No.
Did you make any phone calls to any police agency that day when you were at or near your son's home?
No.
Did you play any role at all in getting your son released from custody that day so that he could turn himself in on the child abuse warrant?
No, he was never in custody.
Did you ever see him in cuffs?
No.
Now, you have made a previous statement in your answer to request for comments when you were asked about your relationship with your grandsons. You recall that?
Yes.
And you testified that you had a great relationship with your grandsons. Is that right?
Yes.
And that you had no problem getting along with Gary, except when Gary Jr., except when you had to reprimand or admonish him. Is that right?
Yes.
And that didn't happen very often, did it?
Right.
Did he appear to love you?
Yes.
And did he appear to enjoy spending time with you?
Yes.
You, on direct examination, you gave us a long list of things that you did with the boys, but one thing you omitted was whether or not you had sleepovers. Did they sleep over at your house?
Yes.
How frequently?
Maybe at least once a month.
And do you believe you had a strong grandmother-grandson bond with Gary?
Yes.
Do you believe he confided in you?
He confided in me once.
Did you testify in juvenile court that he confided in you without qualifying it to one time?
I don't remember testifying in juvenile court about confiding.
If you
Using that term confiding, I'm not certain that I recall.
Okay, if you did say that, would it have been truthful?
I'm sorry, can you repeat the original question?
If you did testify in juvenile court that Gary confided in you, would that be a truthful statement?
I'd say so, yes.
Now, you also testified or answered in your request for comments about your relationship with Russell. Is that right?
Yes.
And you testified you had a great relationship with him too, right?
Yes.
And that he appeared to love you and appeared to enjoy spending time with you?
Yes.
And that you and he also had a strong grandmother-grandson bond?
Yes.
That he slept over at least once a month?
Yes. Well, can we specify the time frame for the sleepover?
All right, so we're talking about before June 24th of 2018. Did the boys sleep over once a month?
Well, not their entire lives. That's why I'm trying to establish a beginning of when they slept over once a month. Because when they were younger, they didn't sleep over a lot.
So let's say between 2015 and June 24th of 2018, how frequently did they sleep over?
That would be about.
And you also answered that you had to discipline Russell once when he was 4 or 5 years old, and you made him sit in the corner. Is that right? And other than that, you and he had no issues getting along. Is that fair to say? When is the last time you had contact with Corey Brussler?
I don't recall. I don't believe I've had any contact at all with her since the divorce in June of 2015. I saw her at the family team meeting, but I don't think there's been any other contact.
So since June of 2015, you have not had contact with her or have any sort of relationship with her. Is that fair to say?
Yes, that's.
You said today that you didn't know that your son was physically abusive to Katie. Is that what you said today?
Yes.
In your answer to your request for comments, the second set, you told the commission that Katie told you that your son slapped her once in the past. Did Katie tell you that?
She did. Yes.
And you also answered that one of your grandsons told you that their father, your son, choked Katie, right?
Yes.
So if you knew that she was a victim of a slapping and a choking at the hands of your son, how do you conclude that he was not physically abusive to her?
Well, first, I would need to believe what she said. Second, the incidents that you were just describing occurred years apart. So I didn't have a close relationship with Katie. Whenever I had any concerns at all about anything that was happening in my son's home, I would go directly to my son. And he always, well, I don't want to say what he said, but he always assured me that there was no problem.
Are you aware that sometimes sons lie to their mother?
I am aware of that, yes.
And are you aware that a son would not want to admit to his mother that he was physically abusive of his wife?
I imagine that's true, yes.
Now, you also knew that your son was violent against Corey Brussler, didn't you?
No, I only saw evidence of violence by Corey Brussler against Gary.
Well, did you read Judge Cox's 2015 motion transcript that you wanted Ms. Apple to read?
The motion?
So let me rephrase the question. Did you read a transcript where Judge Cox made some rulings in your son's custody case involving Corey Brussler?
Yes,
And were you aware that Judge Cox made the finding that both Corey and Gary were abusive to each other?
yes,
And you read that opinion in 2015 shortly after he wrote it, right?
I believe so, yes.
So you knew from the children and from Katie that he was abusive to Katie. You knew that Judge Cox's opinion was that Gary and Corey were abusive to each other. Is that right?
Yes, I knew that that was Judge Cox's opinion. Yes.
And you were aware that Judge Cox prohibited both parents from using corporal punishment on their children, right?
Yes.
Now, have you ever said under oath that you're aware that, right now, have you ever said under oath that the boys told you that they've been spanked by their father for misbehaving?
Yes,
So you have been aware that their father spanked them, is that correct?
my testimony there was in reference to before the divorce.
So the divorce occurred in April of 2015, is that correct?
Yes,
Now, when you answered the commission's request for comments, you did not qualify your answer by saying, I was aware of the spankings, but I believe they only happened before April of 2015, right?
right.
In fact, the first time we're hearing that statement is today, isn't it?
I don't know that. I don't know that.
Well, let's go through your previous statements. You testified in juvenile court, right?
Yes.
Did you tell the juvenile court that you were aware that there were some spankings?
Not spankings. I don't think that was my testimony.
Okay, I'm going to show you your juvenile court testimony. Let's do it this way. When you answered the commission's request for comment, can I just ask, is it okay if I stand here rather than the podium?
It's fine with me. Are we able to pick her up there?
Yeah, there's a mic right in front of you, just be loud.
Okay, so when you answered the commission's request for comments, you did not qualify your answers by saying, I was aware of the spankings before April of 2015. Is that true?
Your Honor, can the judge see the statement if she's reading from it? So she has an opportunity to refresh her recollection?
Certainly.
She hasn't said she needs her recollection refreshed yet.
Well, if you're reading from it, then it's only appropriate that she has an opportunity to see it.
I'm not reading from it, I'm reading from my own notes.
All right, let's continue. Judge, if you need to be refreshed, let us know.
So Judge, when you answered the commission's request for comments, and you said the boys told you they had been spanked by their father for misbehaving, you did not qualify that and say they told you that before April of 2015. Is that correct?
I don't remember that specifically, but if I didn't qualify it, it was because I didn't think that that was something that I needed to qualify. I knew that they had been spanked. I knew that it was before the divorce, and then there was the no corporal punishment order. So when I was just answering the questions that were asked.
I'm going to share my screen and I hope this works. If not, we'll need some help.
Just give me a question. When I feel my shoulder, how did you want it? So it's a matter of
Okay.
if it works on her end.
So,
It should
that
show up
screen.
on the screen.
And so the witness would have to turn it on.
All right, Judge, behind you is a screen. So I'm going to ask you some questions based on what you see. First of all, can you see the printing on that screen?
I can see it, but there's a glare.
If you need to move so you can see it without a glare, I'm sure the judge would have no objection.
I can see it.
Okay. So I'm
One,
going to.
one moment, please. We're going to turn one of these lights down to see if that will work better.
Judge, is it possible to remove the split screen so that
I do see it better now.
the document, but I can't see it unless I walk up and stand by the bench, so.
That's how our system is set up.
If Mr. Ashcraft wants to stand behind me and see my computer, I have no problem with that.
And apparently that, I don't have any problem with you moving around and standing behind Ms. Weingarten.
Thank you, Judge.
So Judge Green, you're able to read that. And Mr. Ashcraft, are you able to see from that vantage point?
I can, thank you.
All right.
All right, Judge, I'm going to scroll up to the question because what you see right now is the response.
Yes.
So you were asked in question 14 on November 21st of 2019. Question 1A. How did you become aware of corporal punishment? Do you see that question?
Judge, it's not 1A. The full question starts with the number.
Okay, I'll go up. Question 14 was, were you aware that your son used corporal punishment on his children before June 24, 2018? If so, do you see where I am, Judge?
Yes.
Okay, I'm going to scroll down and go to question A. How did you become aware of any corporal punishment? B, did you ever, well, we'll skip B. And your answer to A was, once in the past, Gary Jr. told me that he had been slapped in the face by his father. I saw what looked like a handprint on his cheek at that time. My grandsons had also mentioned in the past that they had been spanked by their father for misbehaving. Did I read that correctly?
Yes.
Now, you didn't say they told me this before April of 2015, did you?
I said in the past. That's what was meant by that.
So by saying it was in the past, you meant before April of 2015.
Yes.
But you admit you didn't say that, did you?
Yes.
You were also, answered in question, oh, I'm sorry. I'm also going to show you exhibit, question number 16 and ask you some questions about that. Question 16 reads, if you did not witness any corporal punishment by your son upon the children, were you ever told by the children that your son struck them? If so, do you see where I am on that?
Yes.
Okay. And I'm looking at 16A. Which child or children told you and when did each do so? And your answer to A was, once in the past, Gary Jr. told me he had been slapped in the face by his father. I saw what looked like a handprint on his cheek at that time. My grandson had also mentioned in the past that they had been spanked by their father for misbehaving. Was that the answer you gave?
Yes.
Now, you didn't say that in that answer that this happened before April of 2015, did you?
No, I didn't.
And in fact, the question asked of you was, we asked, and when did each do so, right?
When did each child tell me?
So question 16A says, which child or children told you and when did each do so, right?
Yes.
You didn't answer sometime before April of 2015, did you?
No, I didn't. I said in the past.
Now, you also testified, or you told the juvenile court that you knew their father used a belt on the children, right?
Yes.
Now, would you
And
agree?
turn around.
I'm sorry. Oh, yes, please turn around. Would you agree that a slapping across the face, spankings, and the use of a belt on a child all constitute corporal punishment?
Yes.
Ms. Weingarten, are you going to be sharing your screen again?
I hope not.
Okay,
So I
we'll
will.
turn the light back on then. And
Then you just have to turn off the share screen. Otherwise it'll stay up.
Oh, I see. Stop sharing. Got it.
There.
Now, you just told us that handprint, slap across the face, spankings, and a belt constitute corporal punishment in your mind. Is that right?
Yes.
Did you ever report to Judge Cox or CPS or anyone that your son was violating a court order prohibiting corporal punishment on his children?
No, because I never knew that he was violating.
Your son's rights were terminated in juvenile court to his children. Is that fair to say?
Yes.
And he held a bench trial in the criminal court, and he was convicted of 2 counts of child abuse in the 2nd degree, right?
I'm sorry, I'm not certain about the exact charges, but I know that there were convictions, yes.
And you know he was sentenced to 4 to 10 years in prison, right?
Yes,
Now, you told us that you had some conversations with Ms. Apple, one of which was by phone after the family team meeting. Is that right?
yes,
And you told her that your son is a very strong disciplinarian, didn't you?
yes,
And you told her that you never thought it was this bad, referring to the abuse, right?
yes,
And you're aware that Exhibit 16, where Ms. Apple documented her conversation with you on June 26th, shows that she wrote down that you told her that your son is a very strong disciplinarian, and you never thought it, meaning the abuse, was this bad, right?
no,
You don't think Exhibit 16 shows that?
exhibits, I'm sorry, I'm not sure about what you mean by exhibit 16.
Okay, so let me explain that Exhibit 16 is one of the CPS investigative reports, and it includes Ms. Apple's entry about your conversation by phone with her on June 26th of 2019.
Okay.
Do you know now what I'm talking about?
Yes, I do.
Okay, so are you aware that your statements that I just read to you, and I can read it again if you want me to, appear in Exhibit 16?
Yes,
And you heard Ms. Apple testify on September 27th that you made that statement to her, right?
yes, but the it that I was referring to was discipline in general. I explained earlier that I thought that he would discipline in a way that was proper, but that I did not agree with it. Usually it was that I didn't agree with why the children were being disciplined, but sometimes I thought that the amount of time that they would be disciplined was excessive, et cetera. So when I said that to Ms. Apple after the family team meeting, I was referring to what I had observed compared to what I learned had happened on June 24th.
You didn't share with Ms. Apple that your son used timeout or being in your room or having privileges taken away as his method of punishment, did you?
I don't remember sharing that with her, but I would imagine that she would have asked me, and if she had asked me, I certainly would have told her that.
But you heard her say that, testify, and you read the document that said that it was physical abuse, child abuse that you were referring to when you said it wasn't this bad.
I did hear her say that, but that was her interpretation of what I said. That is not at all what I meant.
So Ms. Apple got it wrong?
She certainly did.
Do you think she lied on you?
I don't think that she lied. I think that she had confirmation bias. I think that she saw and interpreted what I said the way that she wanted to support what she wanted to do, which was not to place my grandchildren with me.
So you testified in juvenile court on March 13, 2019, is that right?
Did you say the 13th?
Yes.
Yes,
And you were asked whether you told Ms. Apple that you knew your son was a very strong disciplinarian and never thought it was this bad, right? Did you ask that question?
yes,
And your answer was, I remember telling her, meaning Ms. Apple, he was a very strong disciplinarian. I don't think I used the term strong. I think I said stern. Do you recall testifying to that?
yes.
You did not deny in juvenile court that you told Ms. Apple you never thought it was this bad, did you?
I didn't, but I didn't know that she was interpreting it to be physical discipline.
And you didn't tell the jury in juvenile court that you never told Ms. Apple that you never thought it was this bad, right?
That I never, I'm sorry, can you repeat?
So you don't deny telling Ms. Apple that you didn't think it was this bad, and you didn't tell the juvenile court jury that you didn't tell Ms. Apple it was this bad, right?
I wasn't asked about any further clarification. So no, I didn't tell the jury that.
Now, you heard Ms. Apple testify, and you heard her say that she had this phone conversation with you on June 26th of 2018, right? Right after the family team meeting.
Yes,
And you heard her testify that you told her you heard your son yelling at one of the children and heard a slapping sound and saw a handprint on Gary Jr.'s face, right?
I heard that.
And you saw that documented in Exhibit 16, didn't you?
This, we're talking about the same CPS report?
Yes.
Yes, I saw that.
Okay, but your testimony is that the slapping incident occurred when you were not present?
That's true.
You didn't tell Ms. Apple that, did you?
I didn't tell Miss Apple that I heard the slapping incident. I wasn't even there.
So she got that wrong too.
I believe that she lied about that. I don't think she got it wrong.
Because Ms. Apple was just out to get you, wasn't she?
Well, Miss Apple may have been. She was out to the house on the 22nd and didn't catch any abuse there. She's back 2 days later, and then there's abuse discovered. And so I would imagine that Miss Apple had a lot on the line.
Did you know Ms. Apple prior to her and your investigation in this case?
I don't think I'd ever met her.
Never worked together? Never had to cross-examine her as an attorney?
I don't think so.
So, do you know whether your son had a relationship with Ms. Apple outside of her investigation of the abuse case?
No, I don't know.
But you have no reason to believe they had a relationship, is that fair?
Yes.
And yet you're saying that you believe Ms. Apple lied on you and on your son?
What I'm saying, Ms. Weingarten, is that Ms. Apple said that I heard a slapping sound, and whatever occurred after that, that was not true. And she absolutely did not hear me ever say anything even like that.
Did you hear your grandson's testimony in this hearing where they said you were there the day that happened?
No, I don't recall that testimony. No. And may I clarify?
No. You agree that it is not reasonable parental discipline for your son to slap Gary Jr.'s face and leave a hand mark. Is that right?
I think it's inappropriate. It may be reasonable. If
Well,
we're talking about the legal standard of reasonableness, it's an objective standard. I don't know if a court or a fact finder would find it reasonable, but I thought that it was inappropriate.
did you answer under oath to the commission that it was not reasonable parental discipline for your son to slap Gary's face and leave a handprint?
I may have used the term reasonable, but I meant it in the everyday colloquial sense, not in the legal sense.
I'm going to again screen share with you.
Judge, may I move around?
Yes,
for a
certainly.
minute? Thank you.
No need to ask if it occurs again. We'll do that. We'll dim the lights to do whatever we need to.
Thank you.
All right, I'm referring to Exhibit 3, page 9. Okay, now question number 14, where we discussed this earlier. Were you aware that your son used corporal punishment on his children before June 24th, 2018? Are you with me there?
No,
It's not showing up on that screen for some reason.
My computer says I'm screen sharing.
Your document may not be up.
Let's try it that way. Share.
Pull up your document, basically get everything ready, and then screen share.
Okay. Okay, I think it worked. Judge, can you see from your seat what I'm showing you?
Yes, I can.
Okay. Question 14 was, were you aware that your son used corporal punishment on his children before June 24, 2018? Can you see that?
Yes.
And question Roman numeral 8 is, did you believe any corporal punishment you witnessed constituted reasonable parental discipline? Do you see that where I am?
Yes.
And did you answer, I never witnessed my son nor anyone for that matter strike one of my grandsons. While I was made aware of the slapping incident, seeing what looked like a handprint on his cheek, and considering it totally inappropriate and unacceptable, I immediately contacted my son and scolded him for doing so. I did not and do not consider that reasonable parental discipline. Do you see that on number 8?
Yes.
Did you swear to that under oath?
Yes.
So do you agree that it was not reasonable parental discipline for your son to leave a slap mark on Gary Jr.'s face?
I do agree that it was not reasonable parental discipline in the everyday colloquial sense. I wasn't attesting to my belief about meeting the legal standard. I also said inappropriate or unacceptable. I was using those 3 terms interchangeably.
Okay, so you've said that it was inappropriate, unacceptable, and not reasonable parental discipline. Is that fair to say?
In my view, yes, ma'am.
And yet you covered up that inappropriate, unacceptable, not reasonable parental discipline mark on his face, didn't you?
Yes, I did.
And to be clear, you never put medicine on Gary Jr.'s face, did you?
Certainly I have. Russell too.
For what purpose?
They fell, scraped themselves. Or I kept Neosporin because I had grandchildren in my medicine cabinet.
But on the occasion where you saw the handprint on Gary Jr.'s face, you did not put medicine on it, right?
Oh, no, there was no broken skin. It was just a faint outline. Handprint.
This is a yes or no question. I think I'm done with screen sharing. Stop this. This is a yes or no question. Did your son share with you why he slapped Gary across the face? Yes or no?
Yes.
Approximately what time did this incident happen?
Are you referring to my observing the handprint and finding it?
Yes.
I know it was in the evening, but I can't say for sure what time because I don't even remember when in terms of the date that it happened.
How long after you had custody of Gary for that evening did you notice the handprint?
I don't know.
Do you know where you picked him up from?
I don't, because I don't remember the date. I don't even know. If I knew the date, then I would know what day of the week it was, and I could try to recreate what we were doing.
For how long did that mark stay on Gary Jr.'s face?
Actually, it wasn't long at all. Before he went home, I could barely see it anymore.
Could you not barely see it because you had makeup on it or because it was fading?
Because it was fake.
So if the mark was fading quickly, what was the purpose of putting makeup on it?
To make him feel better.
Did he ask you to put makeup on his face?
I don't remember if he asked me to do that. I know that he told me that he was being teased by Russell, and he didn't object to it. I said, let me see if I can just make it go away. And
Now,
I did that.
You testified earlier that having a handprint on his face was humiliating to him. Is that right?
I believe it was,
Now, you've raised 3 sons, right?
yes.
Do you think putting women's makeup on a boy is a humiliating thing for that child?
I hadn't considered that.
What about now? Consider it for a moment. Do you think that would be humiliating to a child?
No, not necessarily. And I think he would have told me. I think he would have said, no, Granny, I don't want that. But he didn't.
Changing the subject now. In the spring of this year, you had text and telephone conversations with Gary Jr., right?
I'm thinking about the text. Yes, I had text and telephone conversations.
And he initiated all the conversations, right?
Yes.
You were aware that he was a key witness in this proceeding, weren't
Yes,
you? You told him you love him, right?
I did.
And he didn't bring up the facts of this case, did he?
No,
But you told him the reason you put makeup on him was to prevent Russell from teasing him, right?
I did not tell him that.
Did you hear Gary testify to that?
I did.
But you're denying that you told him that.
I am emphatically denying that I told him.
Isn't it true that you were trying to get Gary Jr. to adopt your defense in this case, that you put makeup on his face to prevent teasing?
No,
You knew it was wrong to communicate with him about this case, didn't you?
yes,
You knew that at best, it created an appearance of impropriety that you had any communication with him at all, right?
Judge? Can
What's
we
the
talk about a
objection?
specific time frame here? The question is ambiguous and vague as to time.
So we're talking about when you and Gary Jr. had communication in the spring of this year, before the hearing started.
yes,
You knew that he was a key witness in this case, right?
yes,
And you knew that by communicating with him, it created an appearance of impropriety, didn't you?
no, I didn't know that it created an appearance of impropriety. Gary contacted me. He's
You're
my,
a criminal court judge, right?
yes,
You put people on bond all the time, right?
yes,
And one of the conditions of their bond is that they cannot have contact with victims or witnesses who are going to testify against them, right?
in criminal proceedings, yes.
And the reason for that is you want to avoid any possibility that a defendant might do or say something that is frightful or scary to a witness or a victim, right?
No, the reason is to protect the complaining witness in case there is any violence, in case the complaining witness is afraid of the defendant, in case the complaining witness fears that the defendant will harm them during bond.
But it's also to protect witnesses who are going to testify against the defendant from any contact with the defendant, right?
It could be, but the two factors to consider are safety to the public and whether the defendant will return. So that's what I focus on.
Okay, so hold on. Those 2 rules apply in setting a bond, a monetary bond or a personal recognizance bond, right? That does not have anything to do with the conditions of bond, like no contact with the witnesses, right?
Well, they do have to do with one another. I would disagree with that, Ms Weingarten, but I get the point that you're making.
Okay, so the point I'm making is that judges in criminal courts set bond conditions so that the defendant cannot have contact with witnesses that are going to testify against them, correct?
Right.
And part of the reason is for the protection of the witness, right?
Yes,
Now, in this case, you had contact with one of the key witnesses against you, didn't you?
yes,
multiple times, right?
Yes,
And you knew that that created an appearance of impropriety, right?
no, I wouldn't agree with that. And the reason why I wouldn't agree is because Gary Jr. was living with his mother's relatives. His grandmother knew he was in contact with me. I assume that his mother knew at the beginning of the contact, but she certainly knew at some time while we were contacting one another.
Did you hear the testimony that Gary had no contact with his mother from October of 2020, that he had moved out of her home?
Yes, but that wasn't true.
So Gary's lying about that?
I think he may not have remembered that he had had contact with her, that he, I don't want to say what he said, but he had contact with his mother when she learned that he was contacting me.
Now, you testified in the juvenile court that you told Miss Apple that in the past the kids would get spankings, right? And you also testified here today that the children told you that, right?
Yes,
But you never asked them what a spanking was, did you?
I thought I knew what a spanking was.
Did you?
I've never heard anyone describe a spanking other than an open-handed swat. That's what I've always considered a spanking to be.
Did you hear your husband testify the last time we were in court that in his mind there is no distinction between a spanking and a beating?
Yes, and he testified that way, I'm certain, because of these proceedings. We're using beatings, spankings, corporal punishment, all kinds of terms, and they're not necessarily descriptive. I think it would be better if we just consistently described what it is that we're referring to, but we use these descriptions, and it can be very confusing. But for me, a spanking is an open-handed swat.
And you knew that that would constitute corporal punishment, right?
Yes, but that was before the children were given, the custody of the children were given to Gary.
Every single time you've been asked about spankings, you have never said that those spankings occurred in your mind before April of 2015, right?
I don't know if I never have, but I wouldn't dispute that. But the reason is because I knew I said that it was in the past. And I'm recognizing now that I probably should have been more specific, but that's what I was referring to. In the past, they told me in the past, and it happened in the past, that being before the custody order.
Now, you're a lawyer and a judge, right?
Yes,
And you know that in courtrooms, every word and every sentence is picked apart to get to the truth, right?
yes, we know.
And that every statement someone makes under oath needs to be entirely thorough and truthful so that it can't be misinterpreted, right?
Yes.
And yet, in your answer to request for comments, you did not say, I knew of the spankings before April of 2015, right?
Correct.
And when you testified in juvenile court, you did not say, I knew about the spankings before April of 2015, right?
Yes, but I was never asked specifically when did you have this knowledge and when did the spankings occur. I thought that excuse me.
And you didn't clarify your answer by adding that fact either, did you?
I thought that my answer was clear. Ms. Weingarten, I didn't even realize that it was a problem until it was raised in these proceedings.
And when you answered the commission's request for comments, you said you did not tell them it was before April of 15, right? That you were aware of spankings?
I'm sorry, can you ask
When
the
you-
question once again?
As I showed you previously, your answer to request for comments, where you
Yes.
were asked about spankings, and you did not tell the commission in your sworn answer that you knew of spankings before April of 15,
That's
right?
correct. Yes,
And in your answer to the complaint, both the answer and the amended answer, you did not amend your complaint to say, I knew of the spankings before April of 2015, did you?
I didn't know that it wasn't clear. But The answer is correct.
Now, you told us about an incident on direct examination where you came over to the Davis head house and Russell shared with you that he was about to get a whooping. Remember that?
Yes.
And in fact, you, in your answer, your sworn answer to the complaint, you used the word whooping, right?
Yes.
Now, were you sensitive to the issue of child abuse as a grandmother and as a family court lawyer?
I would say so, yes.
And you knew that your son had a prior history of physical abuse against his children, such that Judge Cox needed to impose a no corporal punishment order, right?
No, I wouldn't agree with that. Judge Cox told Gary that he could not use corporal punishment. I did not interpret that to mean that Judge Cox had determined that Gary had abused his children prior to the custody.
Do you think it is standard in a custody order that a judge tells a parent you cannot use corporal punishment on your child?
I don't think there's anything that's standard in a custody order. They're fashioned to meet the needs of the family, case by case. But I certainly have.
In fact, you testify that parents are allowed to use physical discipline on their child, right?
Yes.
That's legal in Michigan, right?
Yes.
So getting back to Judge Cox's order, where he imposed no corporal punishment on your son,
Yes.
you're not aware that the reason he did that was because Judge Cox believed your son was using corporal punishment?
No, I am aware of that. I do agree with that. What I don't agree with is that he ordered no corporal punishment because he had made a finding that there had been abuse. That's what I disagree with.
But you never asked either of your grandsons to define for you what they meant by spankings, right?
Well, when they told me about spankings, and again, this was before the custody and divorce case, they were very young. I assumed I knew what spanking meant. I can't even imagine, even if you're using corporal punishment, that you would use anything other than an open hand with a small child.
So I'm going to go through a list of questions and ask if you asked your grandchildren these questions. Did you ask them how they were being spanked?
No.
Did you ask them how many times they were spanked during each incident?
I can't say whether I asked or not because it happened so long ago, I don't remember the specific conversations. I just remember that during the time before the divorce and custody order, Gary Sr. was using spankings on the children. And they told me back then, I think that's where the confusion is coming. When I say in the past, I meant that they told me in the past about what was happening in the past.
Did you just testify that your grandchildren told you they were being abused and then you corrected your statement to be saying spanked?
If I did, I corrected myself because what I was saying was true. You used, Ms Weingarten, you used the term abuse, and I was trying to clarify that there was never any allegation by my grandchildren, and they would have been too young to know the difference anyway, using the term abuse. I only heard about spankings.
Did you ask your grandchildren how often they were being spanked?
No.
Did you ask them with what instruments they were being spanked?
No, I don't see spankings as involving instruments.
Did you ask them what they did to deserve being spanked? I'm sorry.
Well, I'm thinking, I don't know because I don't know the specific instances.
Did you ask them how severely they were being spanked?
I'm sure I didn't ask them.
Did you ask them what body parts were being spanked?
No, I assumed I knew that it was on your bottoms.
Did you ask them whether they were injured for being spanked?
No.
Did you ask them whether they needed medical treatment after being spanked? Now, you were aware that your son disciplined the boys with a belt, right?
I became aware that he had disciplined.
You became aware, and you claim you became aware when?
After the custody order was entered. I read the order. I read the transcript of Judge Cox's opinion sometime after that. So I became aware after the divorce and custody case.
And that would be in 2015, right?
Yes.
So by the time you testified in juvenile court in 2019, you were aware that your son had disciplined the boys with a belt, right?
Yes. Prior to 2015, he had disciplined with a belt.
Now, when you testified in juvenile court that you were aware that your son disciplined the boys with a belt, you didn't qualify your answer and say before 2015, right?
Not unless it was specifically asked. No, I don't think I did.
But again, you're a lawyer and a judge, and you know how important it is to be very clear when you're under oath, right?
I do, but it's not as easy as it looks, Ms. Weingarten. I can assure you, it's just not it's not an exact science that way to testify.
When you testified, strike that, when you answered the commission's request for comments, did you tell the commission that you learned of the use of a belt through the CPS investigations and judicial proceedings?
I learned of the use of the belt for the June 24th incident from the CPS proceedings.
So you were aware that a belt was used before the June 24th incident as well as on June 24th. Is that fair to say?
Well, just to be clear, and I want to make sure I'm clarifying, I was aware certainly of the June 24th incident, that there was a belt used. And I became aware almost immediately after the custody case that belt was used prior to the custody order.
Just to be clear, on both occasions, it was your son who used the belt on the boys, right?
I'm not certain. I know that, well, for June 24th, yes, that's certainly true. But for prior to the custody order, I know that Judge Cox said that neither of them could use corporal punishment. I don't know if there was a belt involved with Corey. I only know about the black eye with Corey.
In May of 2021, did Max share with you that he had gone to Kids Talk to talk about a letter he was asked to write to Dear John?
Yes.
Did he admit to you that he lied and said you were the one who encouraged him to write that letter?
Yes.
Did you tell him to correct his lie?
No.
Did you tell him to tell the Kids Talk interviewer that he had lied to her?
No.
Did you tell him to report to me or to Mr. Helen or anyone at the Judicial Tenure Commission that he had lied?
No.
So you let this lie stand?
There were two conversations.
The question was, did you let the lie
Well,
stand?
Judge, the question was, did you let the lie stand? And now she's answering the question, and now she's cutting her off. That's inappropriate. She didn't say this was a yes or no question, and she didn't phrase it as if it were a yes or no question.
May I rephrase the question, please?
You may.
Judge, did you let Gary Jr.'s lie that you were the one who told him to write the Dear John letter stand without urging him to correct it?
I did not urge him to correct it. I knew it would be corrected.
You knew that the Judicial Tenure Commission, or strike that you knew that disciplinary counsel was investigating the facts behind the Dear John letter, right?
I came to learn that, yes. Gary Jr. called me on May 12th. I think that was the same day that he interviewed with you, and he was in a panic. And that day, he mentioned nothing about what he discussed with you. He just asked me, is it okay that I let them know that I was talking? And I told him, yes, of course, it's okay. Your mother knows, your grandmother knows, We haven't talked about the case. The very next day, which was the 13th, he called me. He couldn't speak for a long time because his maternal grandmother was coming to pick him up, and he wanted to talk to me before she saw that he was talking to me. And it was then that he told me the details of what he had discussed with you on the 12th, because he wanted me to go along with the lie. And he got off the phone abruptly because he did not want his maternal grandmother to see him talking to me. I never even had a chance after the initial shock of it to respond to him telling me this. But he assumed that if he told me that I would go along with it.
So he didn't ask you to go along with it?
He did ask me to go along with it.
And you didn't say no, did you?
I told him that I was going to be okay. He needn't worry about me. I didn't answer it directly at all.
And you didn't tell him that he needs to correct this lie that was going to get you in a lot of trouble?
No, I didn't, because I knew that he was trying to protect his father. I didn't want to be involved with that in any way. I knew that the truth would come out, and it did.
And at this point, you're a judge.
Yes.
Last summer, right? Last spring.
Yes.
Now I'm changing the subject now to talk about the makeup. You heard Miss Apple testify that you never told her that you put makeup on Gary Jr.'s face, right?
Yes.
Was she truthful when she testified?
I don't know, because I don't know if I told her that.
And you never told her that you put makeup on his face to prevent Russell from teasing Gary, right?
Well, I don't know for certain if I told her about the makeup, so that would be a correct statement, yes.
In juvenile court, you didn't tell the lawyers that you put makeup on a handprint on Gary Jr.'s face to cover something other than a bruise, did you?
No, I didn't.
But at that time, you were aware that you had used makeup to cover what you describe now as 3 fingers.
When I was on the stand was years after the makeup incident occurred. I had completely forgotten about it.
You forgot you put makeup on your grandson?
I forgot that I put makeup on the handprint.
Well, you didn't put makeup on him for Halloween, did you?
No.
Or because he was in a school play?
No.
Or for any other legitimate reason?
Well, I do think that the reason that I did it was a legitimate reason.
So are you telling us that in March of 2019, when you testified in juvenile court, you simply forgot that you put makeup on his boy?
Well, Ms. Weingarten, the question was whether I put makeup on bruises. So that never put me in the mindset of, oh, they must be talking about the handprint. This was at least 2 years from the handprint incident. I had completely forgotten about the makeup because it was just incidental. It wasn't something that I found remarkable. I found remarkable the handprint. He didn't ask me about a handprint, he asked me about bruises. And I emphatically denied that I ever even saw any bruises.
And you didn't say, I put makeup on a handprint, right? Because you completely forgot all about the makeup, right?
At that moment, yes. I wasn't thinking about that at all.
Well, there was another moment in May of 2019 when you were interviewed by Mr. Elrick from Fox 2 News, right?
Right.
And he confronted you about whether you put makeup on your grandson's face, right?
Right.
You told him, I did not put makeup on any bruises to conceal any abuse. That's utterly preposterous. It just didn't happen. Did you make that statement to him?
Yes, I did.
And you didn't tell him, I didn't put makeup on a bruise, but I did put makeup on a handprint, right?
No, I didn't tell him that.
Did you forget about the makeup that day too?
No, by then I knew exactly about the makeup. But what I was quibbling with wasn't about the makeup. It was about the reason that I put the makeup on. And I responded very forcefully because he said that I did it to conceal abuse. And that was not why I did it.
But you didn't tell him that, did you? You didn't tell him, I didn't put makeup on a bruise, I didn't do it to conceal abuse, but I did put makeup on a handprint because Russell was teasing Gary.
Right, I didn't clarify that way. No, I didn't. His questions were coming pretty rapidly, and I answered his questions to the best of my ability. I had some restrictions because of the fact that there was pending litigation. I wanted to be sure that I didn't say anything that could get me in trouble with the Judicial Tenure Commission. I just answered his questions.
So you were concerned about the canons that related to what a judge could say to the media, right?
Yes,
But you weren't concerned about being honest and forthright in the juvenile court or to Mr. Elrick about whether or not you used makeup on your grandson.
well, of course I was concerned about being honest and forthright in both of those instances, but because I knew that interviewing with the media in particular was something that could potentially implicate the Michigan canons, I contacted Mr. Helen and I asked him. He was actually very helpful. He gave me the parameters of what I could say and couldn't say. And if I wasn't certain how to keep inside those parameters, I didn't answer beyond what I knew was safe to answer.
So you're telling us that because of Mr. Helen's advice, you did not clarify with Mr. Elrick the fact that you put makeup on your grandson to prevent teasing?
No, that's not what I'm saying at all. What I'm saying is I was hypersensitive to being sure that I said everything that was truthful and that I didn't go awry of the canons by talking about the pending litigation. And so if a question was posed that came in rapid fire and I wasn't able to, in the moment, process, well, first of all, can I answer that? Second of all, if I answer it, is it going to be something that gets me in trouble? I had a lot of things going on in my mind then. I just answered the questions as truthfully as I could.
Do you recall Mr. Elrick's testimony that he had a meeting with you and your Darcy McConnell, who you hired to represent you, and you had a 3-hour meeting before the story aired?
Actually, Mr. Elrick denied that we had that 3-hour meeting, but yes, we certainly had a 3-hour meeting.
You had every opportunity to tell Mr. Elrick your side of the story, didn't you?
Yes,
And you didn't tell him during that meeting that you put makeup on something other than a bruise because Russell was teasing Gary.
I did not tell him.
But you had every opportunity to tell him that if you had wanted to, right?
Yes, and I did not want to.
And you didn't want to because you didn't want to admit to the public that you put makeup on your grandson's face, right?
It's because I did not want to admit to Mr. Elrick, who is, in my opinion, an investigative reporter who is not objective and only cares about promoting seedy stories. And I knew that all he was trying to do was, as I described earlier, confirm his bias. He needed to have the story. It wasn't a story without me, because as I explained earlier, CBS doesn't get involved with slaps across the face. So no, I wasn't motivated to tell him the entire story regarding the handprint, but I told him a great deal of information that if he had followed up on, he would have been able to see what was going on in this case.
The information you provided had nothing to do with whether or not you put makeup on your grandson's face, right?
No, it didn't. No.
Now, you didn't have to talk to Mr. Elrick, did you?
I thought I had to talk to him.
You think you have to talk to a Fox 2 News reporter when they want to talk to you?
Well, yes.
You
They can
hired a media specialist to represent you as a political figure. And didn't she tell you if you don't want to do this interview, you don't have to?
No, it doesn't work like that. When an investigative reporter wants to do a story, and that story involves you, you're going to do the story with or without you. My media advisor told me that it would be better for us to ask Mr. Elrick if he would meet with me to give all of the background information so that he would have enough so that he could independently investigate my claims, specifically regarding Corey, but also the bias in the investigation from CPS. And
So now you're telling us.
Judge, she could, Ms Weingarten cut her off when she wasn't done with her answer.
Oh, I don't
Thank
think
you.
her answer was entirely responsive.
Well, you allowed her to continue to answer the question until you got tired of hearing it, and it cut her off. That's inappropriate.
Thank you. Any response before I rule?
No.
I'm going to overrule the objection, Mr. Ashcraft, and that Ms. Weingarten continues the cross-examination. Certainly, if you need to clear something up, you'll have that opportunity on redirect. Continue.
Understood. Thank you, Judge.
So Judge, you're saying that you felt you had to talk to Mr. Elrick.
yes, because Mr. Elrick was going to publish this story without my involvement, without knowing anything about all of the other evidence that would suggest that I hadn't done anything wrong. He was prepared to do that. He told my media advisor he was prepared to do that. She asked him, can you sit down with her on background? And on background meaning that it's off the record, but it gives context and it gives the reporter a springboard to go and do further investigation. Will you sit with her on background? He insisted, I will not sit with her on background unless she goes on camera. And I will keep the camera footage to use if I publish the story. So he implied that there was a possibility that he wouldn't publish the story after I had spoken to him on background, which is why I spent 3 hours talking to Mr. L, which he denied on the stand.
And in those 3 hours, you did not set him straight about what really happened in your mind, right?
Well, not
Yes,
with
yes or no?
respect to the makeup. We didn't talk about the makeup during the 3 hours.
You didn't bring up the makeup?
He asked me on camera about the makeup, but we didn't talk about the makeup during our 3-hour discussion afterward.
After the interview aired on Fox 2 News, did you ask Mr. Elrick to do a retraction or a follow-up story to change anything that he published?
No, because at that time I was convinced that he wanted to publish the story and was going to do it whether it was based on a complete investigation, a fair investigation, an objective investigation or not.
And you didn't contact any other member from the media to say, hey, Mr. Elrick is painting me in a bad light and isn't telling the whole story. How about you do a story and let me clarify my answer?
No, I didn't.
Now, the first time you admitted to anyone in a position of authority that you put makeup on Gary Jr.'s face was in your answer to the first set of questions dated November 21st of 2019, right?
Yes.
And that's also the first,
I'm sorry, what was the date?
November 21 of 2019.
And that was the first time. I'm sorry, can you repeat the question?
Yes, the first time that you admitted you put makeup on Gary Jr.'s face was in your answer to the first set of questions dated November 21, 2019, right?
Yes.
And that's the first time you gave this story about you put makeup on him to prevent Russell from teasing Gary. Is that right?
Yes, but it's not a story. It's the truth.
So you heard both of the boys testify in this hearing, right?
Yes, in this hearing, yes.
You heard them both say, we never teased each other. There was nothing funny about this. Do you remember that?
I heard Gary say that he never teased Russell, that there was nothing, that Russell was beaten too, so why would he have teased him? I heard Gary say that. I don't remember that about Russell's testimony.
Well, you didn't hear Russell admit that he teased Gary, did you?
No.
And remember me asking him that question?
No, I don't remember.
Gary didn't ask you to put makeup on his face, did he?
No.
Would you agree that most boys who don't have gender identity issues would not want a woman's makeup on their face?
Well, as I answered before, I don't think that it's necessarily, especially if they know that no one is going to see them, something that would bother a young child.
Would your sons have wanted to wear their mother's makeup on their faces?
But it wasn't wearing. This is what I'm trying to explain. He wasn't going anywhere.
Now, in your first answer to the complaint, you alleged 5 times that you told CPS you put makeup on Gary's face, correct?
The first set of answers?
Yes.
I think so. I think it was 5 times, yes.
So are you not certain, or?
Well, I know that that's what I said. I'm just not certain how many times it was.
Okay, you were aware as early as June 3rd of 2021, if not before that, the disciplinary council was seeking to get all of the investigative reports and to get live testimony from the CPS witnesses on the record, right?
I don't remember what I knew at that point. This has been going on for, in my life, for 3 years.
So let's eliminate the date from this discussion. Were you aware that disciplinary council was trying to get a hold of all the CPS investigative reports?
Yes,
Were you aware that that disciplinary council was seeking to have CPS employees testify on the record about their investigation in this case?
yes,
And were you aware as early as June 3rd that disciplinary council filed a motion laying out that we believed you lied in your answer to complaint when you said you told CPS about the makeup?
I don't remember the date, but I certainly remember being accused of lying.
And you knew that we filed motions under the business record exception and under other rules of evidence to try to seek these documents, right?
Yes,
Now, you learned that Judge Widgeon allowed us to take testimony on the separate record of Ms. Apple and 2 other CPS employees, and that testimony was going to be taken on September 24th and 27th, right?
I think those were the dates. Yes.
And you testified on September 17th, right?
Yes,
And for the very first time ever, you testified that you weren't sure that you told Ms. Apple or anyone at CPS that you put makeup on your grandson, right?
that is how it is.
One moment, please. I have no other questions.
Thank you. Mr. Ashcraft, redirect.
Thank you, Your Honor. Judge Green, one of the questions that was asked by Ms. Weingarten during her cross-examination related to question 16 in the first set of questions that was submitted to you by the Judicial Tenure Commission. Do you remember that?
Yes.
That question asked about whether you were aware that the grandkids were struck. Remember that word?
I remember reading it when the sentence was on screen, but yes, I do remember that word. Yes.
Was the word struck significant to you when you framed your response to those questions?
Yes.
Why?
Well, struck has a very specific connotation to me. I don't think that there's any ambiguity about it. Struck means that you were hit, that there was some impact. And I see struck as being a firm or a pretty hard blow.
Ms. Weingarten asked you about whether you knew of any physically abusive relationship between your son and Katie, though she said that you knew about a slap and a choke. Is that right?
Yes.
Was a slap and a choke acceptable?
Not to me. Certainly not choke. But no slap is acceptable either.
Now, Ms. Weingarten also asked you about your discussion with Ms. Apple and the notes in Ms. Apple's report that talked about you didn't know that it was not this bad. You remember that?
Yes.
It was also part of question 16 that she showed you. Do you recall that?
Yes.
Now, to be clear, this was something that she was citing out of Ms. Apple's report, correct?
Yes.
Did you have an occasion and an opportunity to check the report before Ms. Apple issued it to make sure that what she recorded during your telephone conversation was accurate?
No.
Have you ever had an opportunity to speak with Ms. Apple to discuss how she recorded the notes that she put in her report?
No.
This was what you indicated was her interpretation of what you said. Is that right?
Yes.
So let's go ahead and take a moment now then for the benefit of Judge Widgeon. And if you would tell us, please, what did you mean by it was this bad?
I meant the firm discipline. As I explained earlier, I thought that Gary Sr. was pretty firm with his children, and didn't always need to be. That when they were being disciplined, they were disciplined for too long. In other words, they might be hours at a time that they'd have to remain in their room, or they couldn't go on outings. And not just the amount of time, but the deprivation of privileges and things that I observed were done for things that I just didn't think required discipline at all.
Ms. Weingarten was asking you a question about the boys saying that you were at the home and you heard a slap. Remember that?
Yes.
And then you asked if you could explain and she said no. Remember that?
Yes.
Go ahead and explain now if you would.
Well, I read something in one of the reports that made me think, okay, that must be what's causing this confusion. So I was willing to give Ms. Apple the benefit of the doubt, but what I can't say whether Ms. Apple was lying or mistaken. I'm sure she took a lot of information from a lot of people, but I never told her that I heard a slap. I don't even know if that's possible. My recollection is that I was supposed to have been walking up to the house and I heard a slap, and then I came in the house and went upstairs and saw something, but that's not how it happened. I saw the handprint after the boys were at my home and Gary presented himself in my bed.
You were also asked about your statement that it wasn't reasonable parental discipline to slap your child. Remember that?
Yes.
When you say not reasonable parental discipline to slap your child, does that mean when you say that you mean it's child abuse if you do?
No. I know it's not child abuse. Because I've never seen CPS act on that as child abuse.
What do you mean by not reasonable parental discipline?
I mean, inappropriate, something that I wouldn't do myself, something that I would not do myself, something that I would not like to see done to discipline my grandchildren.
You were asked questions about your communications with Gary Jr. in the spring of this year. You recall that?
Yes.
At the time, had he been kicked out of his home by his mother?
Yes.
Was he living with his elderly, is it grandmother or great-grandmother?
At one point he was, and then he was living with his aunt, who had just been released from prison on a murder conviction. And then he was living with his maternal grandmother, who had 4 children's rights terminated for her against her. So I knew he was going not only from pillar to post, but I wasn't comfortable with his surroundings.
So this 13-year-old boy had been kicked out of the house by his mother and was bouncing around different locations to stay. Why did you decide to have communication with him then?
Well, I waited. I spoke to my husband about it. And I decided that I wasn't going to take the chance that something horrible was going to happen to him. He needed to have someone who cared about him, be able to keep tabs on him. And I decided to accept his calls because of that. But I didn't discuss ever these proceedings with him.
And ultimately, this issue was brought before Judge Widgeon, you recall?
Yes.
And an agreement was reached and an order entered that said you should not have communication, any further communication with Gary Jr. while the case was pending, right?
Yes.
Did you?
No. He has contacted Simone,
You've had no communication with him, though.
but I
Ms. Weingarten focused on the time prior to June 24 of 2018, when you indicated that you had seen something different. You became aware when the boys were removed from the house that something else was going on. Are you aware of any child abuse of your grandsons at the hands of your son prior to June 24 of 2018?
No.
Had you ever heard of such a thing?
No, never.
Were you aware of any finding by any body of child abuse of your grandsons at the hand of your son before the underlying criminal case?
No.
Now, Ms. Weingarten asked you if you asked the boys a long laundry list of questions about their spankings, including what instruments were used. Did you have any reason to ever ask your grandsons the list of questions that she asked you if you had asked them?
No, never.
She also asked you whether or not you let Gary Jr.'s lie stand about the Uncle John letter. But it was a yes/no question, and you weren't allowed to give an explanation. Give an explanation now, please. Did you allow a lie to stand?
I did not allow it to stand. I knew that it would be revealed that I didn't have anything to do with that letter. I didn't tell Gary Jr., oh no, you have to go back and tell them that this is a lie, because I did not want to in any way be accused of affecting what Gary Jr. might say to disciplinary counsel. I thought about it very briefly and decided against it. And he then abruptly got off the phone because his maternal grandmother was coming to get him, and he did not want her to see me talking to him. But I knew that it was going to come out. I assumed that there would be some investigation about it and it would come out. So I wasn't concerned about it.
You testified that prior to the time that you had your interview and meeting with the Fox News investigative reporter, Mr. Elrick, that you contacted Mr. Helen. Is that right?
Yes.
This Mr. Helen.
Yes,
Why did you do that?
because I wanted to be sure that I didn't do anything relating to talking to the media while litigation was pending that would go outside of that would run afoul of the canons. And I remembered Mr. Helen giving the training at new judges school, and he offered to call him anytime if we had any ethics questions, and so I did.
Did Mr. Helen on that occasion, prior to your interview with Mr. Elrick, provide you counsel?
Yes.
Judge Green, at any time, were you aware of circumstances that led you to conclude, as a sophisticated person in the space of child welfare, that your grandsons had been the victims of child abuse at the hand of your son?
Never.
I have no further questions. Thank you, Your Honor.
Thank you.
No other questions.
All right, thank you. May Judge Green be excused as a witness and released?
Yes.
All right, thank you. Additional witnesses today, Mr. Ashcraft.
No additional witnesses on behalf of respondent, Your Honor.
All right, thank you. I'm going to ask, I can ask you now, Ms. Weingarten, if you have any rebuttal witnesses.
We do, one, me.
All right, before we go into the rebuttal witness, I'm going to have a 10-minute break, and then we'll come back and get started in that.
Did you say 10?
10, yes. Is that sufficient for everyone?